Hey, good morning again, everybody. Thank you for those of you joining us here in Ajax and via Zoom, and appreciate your patience. I know this was this presentation that was supposed to happen last week, so we very much appreciate Liz and Binu joining us. And today we're covering the topic of the foreign buyer ban, everything you need to know. Thanks very much, Binu. We do appreciate you taking the time.
Not a problem. Hopefully it's everything you need to know. Okay, so in the last few years, there's been, I guess, discussions in government about this foreign buyers ban. And so they passed it into law, but we really didn't know all of the details of it until very, very late last year. And that sometimes happens when a law is passed and then they have to figure out the regulations. So the regulations came out, I think in December of last year, that kind of defined all of the areas that we have to be concerned about or have to do a little bit of investigation in to figure out if a purchaser who you might be representing is going to be in contravention of this ban. So we'll go through sort of the highlights of sort of what those areas are. And so just the first part of it is it's a 2-year ban. It started in January of this year. It's going to end December 31st, 2025. No information on whether that's going to be sort of renewed in the legislation at that time. So it's something obviously to pay attention to. When we talk about what types of properties are covered, if you go online, there's a lot of different information, some good, some bad, some of it not inclusive of everything. So I'm just going to go through what properties are covered. So they are residential properties. The first category is detached homes with no more than 3 dwelling units. So that covers one area there. The second part is semi-detached homes, row homes, and condo units are also covered in the ban. The other part that's interesting, because even one of the pieces of information provided by the Canadian Real Estate Association, they did not cover this. Vacant land is also covered under that ban. You have to look at what the zoning of that particular piece of vacant land. If it's zoned residential or it's mixed use, it could be covered under that ban as well. So, we want to make sure that we're not, falling outside of that. There's a loophole and somebody wants to, buy a piece of vacant land. That could be an issue. The other situation that they don't talk about is even if it does not look like a residential property, you have to look at the zoning as well. So if it's zoned mixed use and you don't believe that it's a residential property, it could still be covered under that ban. Now, obviously, the situation is there hasn't been any litigation to kind of flesh out what these definitions are. Are there any exceptions that will be granted to that? But it's important to understand that that could be something that's covered under that ban. So the regulation, if anybody wants to read, it's not that long. It's not too dense, but if you want to look at the regulation, it's SOR -2022-250. It's online. You can look it up, and then it'll give a little bit more information. And the other issue that people are falling into is and are concerned about is there are a lot of exemptions and exceptions to the rule. So an individual who is a foreign individual who's not a Canadian resident, a Canadian citizen or a permanent resident, there are exceptions. International students are exempted. Temporary residents are exempted, and refugee claimants as well. You might not have too many people who fall under that category who are looking to purchase, but just know that there are exemptions, exceptions to the rule. So it's a good idea to take a look at the regulation if you think that somebody might be part of that ban or it could apply to them.
With the student one, there's some pretty tight restrictions on that exemption, isn't there?
Yeah, so it's a good idea to read through that and just to make sure.
Because it looks like nobody will qualify.
Nobody will qualify, exactly.
Yeah, they closed it up pretty tight.
So that's the issue with, what the public knows and what the reality is. So, information's put out there and say, well, these are the exemptions. Okay, well, unfortunately, you have to sort of look at the actual details to that. But there might be some international students who might have, parents or otherwise, or they might have some, funds available to them to purchase. Might be a rail system.
Well, there's a residency required. There's all
Yeah.
kinds of stuff. They have to do income tax for the last 5 years.
Yeah.
They have to reside for so many days and for the last 5 years. There's a lot to it.
Yeah, they're trying to avoid a situation where somebody can claim an exemption under a short period of time, purchase a property, and then, they get around the ban. So like I said, it might not be something that is very common, but it's something to look into if that's something that you find that the client might fall into. I mean, that goes into the sort of the next step is, how do you identify what's the sort of the realtor's obligations? How do you identify the individual? I mean, the same information that you would take from a client generally for FinTrack purposes, making sure that, they've provided identification. It might include taking a look at the individual's passport. If you have any concern, taking copies of that just to make sure that you have that information. There's no reporting requirement for a realtor. So it's not that you have to record this information or report it anywhere. It's that you have to keep it, in your records. If there's a situation where an individual is going to, the government is going to try to enforce this against an individual, you want to make sure, obviously, that you have your records, that you've done your due diligence, because the legislation does say that anyone who sort of aids an individual in purchasing a property, in contravention of the ban, there could be, ramifications for that. There could be a fine, against the individual. So keeping your sort of records of, discussions that you have, copies of individuals' IDs, and then I think that, and Gina and I talked about this the other day, there are, circulating around consents that purchasers can sign, sort of standard forms in which they make declarations that they're not in contravention of this ban. And you can get them to sort of fill that out, sign it. And that's something that you'd want to keep with your records as well. Some individuals are including, I think, clauses in agreement of purchase and sale to sort of cover that as well. I don't know if it's necessary to include it in an agreement. But if it's a situation where, seller wants to be assured that, the buyer isn't contravening the act, then you might want to include that information. But it might be a situation where, buyer's agent and seller's agent have to communicate that information between themselves. So both parties understand that there's no contravention.
Isn't the onus of the buyer agent, like the seller agent, if a foreign buyer buys a seller agent's listing, there's no repercussion on the seller agent, is there?
There's no repercussions,
Yeah.
but I think it's a situation where the seller's agent wants to make sure that there isn't going to be anything that's going to stop this transaction from going through. So just checking those boxes. If the deal goes through, it closes and the seller gets their money and away they go, there's no obligation for them. They're not going to be in contravention of the act. It's all going to be on the buyer. The government might force the buyer to sell the property. So there's no issues with the seller, but in the time from agreement of purchase and sale until closing, the seller might want to have some assurances that the deal will actually go through. No.
Sorry, I just want to, I'm not sure if everybody joining us via Zoom heard Munir's question. He was just asking about whether or not the seller was implicated in any way if a buyer who was under the ban purchased. And that's what the news answer. So,
Gina, maybe could the office actually come up with a clause that we should include in our buyer rep? Because I think that would be the best point for us to have that disclosure from the buyer.
So I actually brought 2 documents that I shared with Binu prior to this meeting, just for him to kind of scrutinize for us and see. One was on Korea has put together, and it's basically a declaration or a certificate of consent from the purchaser for the buy side of things. And the other was a potential clause that we could include on our Schedule B if we want to, in some way, give an extra layer of insulation for the seller. But I wanted Binu to weigh in on those just to make sure that, you gotta be careful when you're adding things in, that you're not creating more of a problem than than what you're intended. And the one difference I wanted to point out is they're saying on the buy side that unlike FinTrack, which is at time of transaction where you can do that, they're actually saying that the buy side, you need to demonstrate that before you even counseled or engaged or started the process, that you've sort of identified whether or not the buyer is in that position. So maybe you can speak to a couple of the forms that I mentioned.
Yeah, I mean, the forms that were provided are good. They seem to cover, what you need to have in there. Once again, in terms of the Canadian Real Estate Association form, if you look through the definitions, it's not exhaustive of
Right.
everything that needs to be there. They'll just basically say, okay, this is, these are the definitions, but it's not exhaustive. You have to sort of look into it. You might have to, if you have a buyer who's concerned about, contravening the ban, go through those regulations with them and make sure that, they're either covered or not. Because I think what Whitney had indicated is, there's so many exceptions that they can't cover it all in that form. But I think for a realtor, having a client sign that probably covers you at that point. So in terms of getting identification from the individual, at the time that they've contacted you, going through the form, having the client sign it, that probably covers you, but you want to make sure obviously that you've covered everything with the client and gone through everything that's in the regulations, because you just don't know. The client's not going to know all the ins and outs of
And
the
I think
regulations.
that's, well, I won't speak for anybody else, I'll speak for myself. I think my challenge with this is they're really pushing the envelope and almost kind of putting the onus on us. And I'm not comfortable interpreting some of this and applying whether or not this person fits one of the exceptions. I mean, you can look at it and you can interpret it, but I'm not sure that I want to be the last person in the chain to go, no, we're good, let's move forward here, right?
Yeah, I mean, I think it's difficult. Obviously, the situation is that they're, on the lawyer side of things as well. We have to, make sure that there's no contravention as well. So we do our ID requirements and everything like that. But I think the question obviously is for a realtor, are you going to be in contravention of the act? Probably not. And you're probably going to be able to say to a client, okay, we went through everything here. The client isn't going to be able to come back and say, okay, well, my deal went through, they're forcing me to sell the property. I didn't know anything about that, because there's going to be multiple layers in which both the realtor is going to get information from the client and discuss things with them, and the lawyer is also going to do the same thing at the end of the transaction.
So would you recommend that CREA form on the purchasing side of the equation is at least a good first step?
It's a good first step, but once again, and just sort of generally, if you look at that form, and I don't know if everybody has it, probably not. There's very broad language there. It's very open-ended. And so if you're a client and you're reading through that, it doesn't really mean much to you. The client's not going to really understand all of that. And they're making those declarations. So there is a part where, you may want to have the individual say or acknowledge that they have looked through those regulations and they know, the sort of the material facts there. So then you can at least say to them, I directed you to where to go to make sure that you're not in contravention, as opposed to just saying, okay, these are the statements that you're making and you've understand everything. It's like any agreement, when a lawyer gets the client to sign an agreement, you have to go to the next step and say, I've explained it in plain language to the individual. So some people might not be comfortable in terms of the interpretation and explanation, but if you direct the client to, the sort of the resource, then obviously the situation is you can probably get them to sign something that says, okay, I've advised you that this is the regulation. You've done your, due diligence and read through it, and you're accepting, the statements that were made there.
Okay.
It's the extra step there.
So I've got a question, but I also want to think that there's been a couple of questions, and I think Greg's question sort of covers what I'm asking. Because we're really only dealing with foreign buyers here, so if they have Canadian passport or they have a PR card, we don't need to worry about this.
No. So I
it's
think,
really that very small portion of
Yeah.
clients that may not have.
Apparently, even they have immigrant status, you know that.
Refugees and PRs, their cards.
No, but not necessarily PR card. I mean, when you apply for immigrant status, they give you that slip, right?
I don't think they're covered.
Is
until they have
that,
the
is
PR
that
card.
covered also?
so temporary residents are also covered. So I think the situation obviously is that it's Canadian residents, permanent residents, and then what we talked about, refugee claimants, international students, temporary residents are covered. I don't think you get that just by the fact that you're here necessarily. You have to fall into some of those definitions. Sorry, Christian.
Who's responsible, if the actual deal only stops, is the lawyer responsible to stop the deal?
I think the situation is that if anybody finds out information that the individual is contravening the act, I mean, the deal can't go through.
Who does that? Who will say?
Well, I think that it depends on what sort of stage you're at. But if it's a situation where there's an agreement of purchase and sale that's signed and it's firm, then the lawyers will have to communicate and say, we can't go through this transaction anymore, and then deal with the ramifications from that. So it gets complicated. It gets complicated at that point, because now you have to get into a detailed analysis of where fault lies, but it's going to be the buyer's responsibility in most cases. And if the seller's relying on the buyer making these statements or these declarations, then the seller is probably going to be able to get damages, compensation, the deposit forfeited. This is something that I talked about before. It's like, in the seller's agent's situation, they don't have to record all of this information because they're not the buyer's agent. But you should probably have this information, because there could be a situation where further information or is found out and then the deal doesn't go through. So then how do you say, okay, well, where's the fault of portion of that? Who has done their sort of due diligence? How did it fall through the cracks? Because your client on the seller end is not going to just be like, oh, well, okay, that's fine, the deal fell through. They're going to be upset about the situation. They're going to say, well, who didn't look into it?
Yeah.
Who didn't get that information? Whose fault is it?
Well, if the buyer signs that declaration that we ask him to sign, and then we proceed and we have a deal, and later on, before closing, we realize or we find out that we've been duped, more or less, and we'll report it to the brokerage, and we'll report it to you, the lawyer.
Yeah.
I guess that's what Christian is saying, like, who stops this deal? Like, who do you report to? Do you just refuse closing that deal?
Yeah, you can't close the transaction.
Yeah, and what if he decides he wants to go to another lawyer?
Well, you can't stop a fraudster in all situations.
No, but
Yeah.
what I'm getting at.
But I would assume in that
At what
I would
point can
assume-
it go to the government authorities to say, hey, this guy is doing so and so? And
Well, you don't, because you don't have a situation, unless the deal closes, you don't have a contravention.
Yeah.
So you don't have anything to report. But the question is if you have purchaser and seller, and the deal doesn't go through because the two lawyers find out that there's a contravention and they don't close the transaction, well, seller's gonna know that information.
Yeah.
So they're not gonna be able to go and take it to somewhere else and be able to close the transaction that way. The deal is gonna be dead. The lawyers are gonna negotiate what the terms of the termination are. And
So
that's where
as a
we'll go.
buyer rep, if that does happen, how do I get my commission? Because I've done my work. Buyer, you.
I have a question, but more for Dean, I guess, management. I have a question that's more for management and also for our industry. I don't think it's an even playing field here. I don't think a lot of agents, like all 70,000 out there, are aware of what the obligations are, because from what I'm hearing, we would be the front line of actually telling people, you can't do this.
Yeah.
Right? We're the ones that are gonna get sued eventually, because we're the ones that will have first access to see, and either continue with this or not. But I don't see any major training or even anything on our association sites mentioning, be careful, this is the next step, this is obligation. And actually, I think a lot more people, like I dealt with yesterday, someone, and I just found out they actually could have bought. Meanwhile, people that I know, in another industry, are telling me they couldn't. They're a refugee claimant, or they've already been almost approved. But it's only 6 months for a PR card. Now I found out they can probably do it. But I think there's a lot more out there than we think. And I find that the onus is on us, but I don't see anything that's been red flagged, on our association. Or anything saying, make sure this is what you follow some of the new rules. Well, like FinTrack came in very strong. This seems to be going through, it's very softly coming in. And I see the onus, especially me, if I'm a listing agent. I'm scared to death of that guy doesn't know what he's, like the other agent isn't, really digging into it.
Yeah.
You know what I mean? Like, I don't see a big training session for everybody on the board.
I mean, I think when the regulations come in December of last year, it's hard for everyone to be prepared for it. I mean, the government knows what they're doing. They pass a law. They pass a law. It goes to committees. These regulations sit on somebody's desk, and then they release it right before they need to, because they don't want too much discussion about it. They don't want too much debate about it. So then now we're in, January and February of the next year, and everybody is sort of going, okay, well, we got to figure out,
I agree
what
with
to
you.
do.
Just, I don't know if agents are aware as much as.
Christian, the way I see it also, and maybe I'm wrong, but based on the FinTrack required documents that we as agents are supposed to check before we sign up that client, I think that's pretty much covering us. The only combination I could think is maybe driver's license and credit card, and if you take those two, then maybe you kind of verify, but every other document that is needed is a passport.
Passport.
Yeah, driver's license doesn't assure you that you're.
No, but that's approved by FinTrack as an ID.
Yeah, but
And even credit.
No, but I think the idea being is you have to look at the person's passport.
Yeah.
I think that's
Passport.
to the bottom. That's the first step. Whether you get more information afterwards after you see the individual's passport is, the analysis part of things, but you have to look at their passport first. You can't rely on anything else.
And we've
That's the
actually
first step.
had a mortgage, it's closing Monday, and in the mortgage instruction it specifically states, solicitor obtain Canadian passport, permanent resident card, or Canadian citizenship.
So what if he doesn't have a Canadian passport,
Then you have to tell the bank and
but he has a PR card, meaning he's a
Well,
permanent
one
resident?
or the other.
Yeah.
like,
One or the
or-
other.
Yes,
It's not,
yes.
Like you said, first step.
Yeah.
You if you don't have that, you go to the next step.
Yeah.
So
get
just
your
on
card.
Christian's point, I think Korea did come out and sort of express their frustration at how quickly the regulations were coming out, and that there wasn't clarity, and they were trying to seek that clarity. And I agree with you 100%, with 70 or 80,000 TREB agents, and this goes across Canada now too, but just for TREB, there's gonna be a lot of people that have no idea. I think as a buyer's agent, it's relatively straightforward. I mean, we can all read the regulations. Yes, we may not be able to interpret everything super clearly, but if there is any doubt on that little tiny sliver of, oh, they're a student who's here for a year, and I mean, that's what I think we would recommend that they go get. Yeah, they go get advice from a lawyer as to whether they're able to buy it. I think our greatest risk is what you said, which is as a listing agent, we really have no capability of demanding that they share with us their client's passport or driver's license or permanent resident card. All we can do is really ask, have you done this?
Mhm.
So as a listing agent, when you were Binu sort of talking about if the deal falls apart, that's when we have to sort of figure out whose fault it is. I don't know how it could ever be the seller's fault at that point.
It's not a fault situation, it's more a client management situation, if you're on the seller's side. Because the seller's not gonna know what the sort of the machine has done in terms of getting this information. So the seller's not gonna have a liability, but the listing
So that's
agent.
the listing agent.
Yeah, the listing agent wants a happy client, right? But at least you can go back to and say, you know what, I did all those steps, I asked all those questions.
Right.
That's basically it.
Because that's really all we can do is just ask the other side. Are you aware of this buyer's ban for foreign buyers? And have you determined that they are eligible to purchase property in Canada?
I guess we need a
Is
clause
that,
that
is that as much as
says,
we can do?
That's covering yourself.
Mhm.
Yeah, that's covering yourself.
We do have an example of a Schedule C that basically has.
Or 309.
Or, yes, so they read the same, yeah. So the 309 in the chat, Patricia, yes, the 309 RIA form would be the equivalent of a statement that gets put as a Schedule C attached to your listing to come in with offers. But to Pierre's point, that only takes you so far, right? I mean, you're having the buyer represent and warrant that they are not banned from purchasing. But at the end of the day, you could actually get this transaction all the way to potentially the lawyer at closing and then have it fall apart at that point. Is there going to be liability on the part of the seller because this person pursued it that far? I think you're saying no, absolutely not. But the challenge is you've got a seller now whose deal just fell through and everybody apparently did everything right, but you can't control the buyer agent on that side and what diligence they did before they brought that. So I don't know if there's an answer to that. I think the best you could do is ask the question and have it in as a Schedule C.
Well, and to be clear, there is potential liability on the part of the seller, because if there's a chain of transactions.
Yeah.
Of course.
Exactly. Sorry, my problem is there's no set guideline. It'd be nice if there was a set guideline, like the Schedule C, or a standard question as part of anything else that we ask.
Right, there's a clause in the APS that says the seller's not a non-resident. We almost need a clause in the APS that says the buyer's not a non-resident.
Is that?
Wonder if that's in the new form that.
I just pulled up one that I did a couple
Sorry,
of
just
weeks
speak
ago.
up just a little.
Sorry, in the APS, there's a clause that says the seller's not a non-resident. We almost need a clause on the APS that says the buyer is not a non-resident. On the condo form 101, I think it's clause 20. I just looked it up.
So,
Because the capital gains.
so what is our thought on sort of Schedule B clause or Schedule C? Like, what is our thought for
Really blind, but Binu, I provided one to you.
Mhm.
Do you have any commentary on it? It's something I obviously wanted to get that way in before we decided that we were going to sort of add this to all of our listings, but.
I don't have any real commentary for it. I think it's fine as it is. And, you know, I think it's something that, you know, it's, if you think that there's a concern, you include that clause and maybe you include it as a standard clause. I don't know if they're going to change the standard agreement. So you might as well cover it with your own clause.
Actually, I love Whitney's suggestion. I hope that's been put forward to ARIA because, right, I mean, it's sort of
How do
the.
we get it forward to ARIA? Is there an email we can send it to?
Yes, what's her name? Cassandra Walker. Anyway, I'll just quickly read out because it is brief and short, but here's what the Schedule C to the listing would be. And it is the 309 that Patricia mentioned. The buyer represents and warrants the buyer is not now and on completion of this transaction will not be a non-Canadian as defined pursuant to the Prohibition on the Purchase of Residential Property by Non-Canadians Act, and then it quotes the act, or is exempt from the act by reason of exceptions defined therein. This representation and warranty shall survive and not merge on completion of this transaction. So, but it's only taking it to that point, right? I mean, you're still, like any of the other things, we're relying on the other side to have done their job to that point, us to have been a secondary check and balance, and I don't know what more.
But I think what that does is it documents, I mean, we can take our notes and say, hey, I asked the buyer's agent that, you know, did you do your due diligence to make sure that this person is eligible to purchase property in Canada? But by having it in the agreement of purchase and sale, I think it documents it for all parties, the buyer, the seller, the agents, the brokerages, the lawyers. It documents for everybody that it was discussed, reviewed, signed off on, and shows everybody that the buyer still signed off on it.
And it's all about legal recourse anyway, so.
Exactly.
So ultimately, you want a documentation that gives you the right to sue as many people as possible. So that,
Your own body.
you know, so that, you know, it basically, you know, you're covered up. I mean, because, you know, hey, it could happen. I mean, as a seller's agent, the buyer, the seller gets so ticked off, he wants to sue everybody. You've got a piece of paper that says, no, I covered myself. And also, I want my commission, and I did my due diligence and blah, 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 blah. We're going after the buyer. Good luck, he's a foreign buyer, so he's off somewhere, she's off somewhere else in a different country. But, you know, what about the agent? What about the brokerage? What about everything else?
We're gonna see listing agents requesting higher deposits.
Yeah, I mean,
Like, that's gonna happen. I've already seen a couple asking for 10% deposit now, which I thought was ridiculous, but it's out there.
I have a thought that's pretty hypothetical. Let's say everybody at the buyer's end has done their due diligence, they have all the paperwork signed. The transaction goes through, all paperwork, everything goes through. So the buyer is well on their way and the seller is on their way, who knows where, and the buyer, they have the money, the buyer has the property, but the buyer doesn't live in the country. But it comes to like everybody, or somebody becomes aware and realizes that that property was sold unlawfully or whatever it is. So what happens to the property? Does it sit frozen or what happens?
It's up for the government to enforce the act. So their recourse is to sell the property. And, you know, what happens to, there's nothing that's going to happen to the seller, and the buyer is going to take the responsibility.
I know nothing will happen to the seller. I can't, can I be right that the government will step in and sell that property?
Yeah.
And the buyer doesn't?
That's the right that they have.
Okay, so that's what I want.
You know, that's the enforcement.
There's a question up there. What happens if a non-resident wants to help a resident family member purchase a property by being?
Sorry, I'm just gonna read it a little bit louder because you're talking in your quiet voice today, Munir, unlike you. What happens if a non-resident wants to help a resident family member purchase a property by being a part owner?
You're banned.
too bad.
Yeah, you're not going to be able to do that.
No.
Because these are schemes to get around the ban. It's the same thing, and there was another point that I was going to get to, using a corporation to purchase a property as well. So you can't use a private Canadian corporation in which the foreign individual owns more than 3% of that corporation. You can use a publicly traded company, but obviously most people won't have one that's being traded on a stock exchange, and you can't use a foreign corporation to do that. So you have to be obviously careful in that situation as well. If somebody says, okay, you know, I'm purchasing this property, I'm using a corporation, here's all the information. Now you have to look at, okay, who's now the controlling mind of that corporation, who's the shareholders, and, you know,
There's a lot of layers there as a buyer's agent that I'm going to feel pretty unsettled about determining that.
Yeah.
So what would?
So I think at that point, it's maybe a stop and saying to the individual, okay, I'm not going to be able to do anything until you tell me, you know, that you have a legal opinion probably that you can purchase.
Okay.
Or show me the PR card or your passport.
But if it's a corporation, if they're using a
Oh,
corporation,
sorry.
yeah.
But the thing is if they're asking you, is this a workaround? It's not. There's no workaround.
There's no workaround, no.
And so in a situation, you've got, say, a young married couple that are living here in Canada and are becoming residents. And the son or the father of the young man owns a company in Brazil and wants to give him the money to buy a house. What happens when he sends money through his corporation to his son to buy the house?
He could buy it.
Is that okay?
Yeah, I mean, the question obviously is that,
Yeah, it's just the thresholds, that's, you're answering my question, so.
He's not going on title, the dad's not going on title, so.
No, but the company is still shuffling the money into the country.
They do that now
Yeah.
anyway.
That's not what this is about.
No.
Okay.
There was another question up there. Should the clause include indemnity for the listing agent and brokerage?
I think you're getting too deep into trying to protect maybe the realtor's interest in the agreement of purchase and sale to include an indemnity there.
Yeah, my instinct was a little bit in that way too, in that we're not a party to the transaction.
Yeah.
So I'm not sure that would be the place for that.
I mean, if you're getting a client if you're on the buyer side and you're getting a client to sign something like the Korea form, if you want to get, have some unique drafting and say, okay, you know what? You're going to provide me with an indemnity based on that, then you might ask your client that. But I don't know if necessarily a client's going to sign that or want to sign that. That might be an uncomfortable conversation to have.
Well, you know what though, Brian, that was your question. I'm just curious, were you kind of thinking in your mind's eye about the seller indemnity form that we had sort of during COVID? Is that sort of the pivot point?
No, I mean, we seem to be bringing up a lot of concern about, what's the brokerage responsibility, or if something goes through, who's going to get sued or what have you. But if the person is a Canadian citizen and they have all the paperwork, then it's not an issue. Like, why would they do that? But if they don't have the paperwork and they can't provide it or what have you, I mean, I personally wouldn't touch the client at that point, but if they have it all, why wouldn't they sign? Why wouldn't they sign to say, yeah, I'm not going to hold you responsible for it?
Yeah.
That's what I thought. And I could work on the seller side or the buyer side, but if that's a concern, a legitimate concern that the brokerage or an individual agent could get sued, that's the only kind of protection that I could imagine over and above what's already there, right?
Mm-hmm.
So I just threw it out there.
Yep, no, appreciate that.
I think if anything, it makes sense to what you said about that what we did for the COVID form. If we were to do anything, that would make more sense than doing anything. Just like commissions aren't supposed to be in the agreement.
And that wouldn't necessarily have to be sort of a mandatory. It could be you've asked the questions, you're not entirely comfortable, even though you've been provided with the information back. Okay, I'll give some thought to that one too.
Just as a follow-up to the question about sort of having someone buy with you, is the only exemption spouse or common law? Is that like if a non-resident is buying a house with a spouse or common law, is that the only exemption that allows?
I'll be honest with you, I don't have the answer to that question right now, so I'll have to look into it and give you the answer.
Thank you.
Quick question, does the PR code expire? Because I had someone tell me their PR code had expired.
Your PR card.
Card, yeah, it expired.
Yeah, it does expire.
Yeah.
You need to apply for your citizenship before. I think it's maybe 5 years or 6 years or whatever it is. They give you the permanent resident card. Legally, you should be living in Canada. And if you're living in Canada, then you lived a number of days out of 5 years, whatever, and you apply for your citizenship. You could renew the permanent resident card.
It does expire, okay.
Yeah.
Another question up there from Greg, commercial and multiplexes, are they exempt from the ban?
Once again, the question comes back to the zoning and figuring that out. But typically, if it's zoned commercial, you're fine. If it's more than 3 dwelling units, you're fine. But once again,
So multiplexes, even if they're residential, they're more than 3
That's
units.
right.
So technically a foreign buyer could buy.
Good purpose.
Could buy an apartment.
Yep.
Yeah, so I guess the commercial properties now, the values are gonna start going up soon. For fourplexes.
Yeah, 4. All right. Is there anything else you want to cover before we can see if there's any more questions?
No.
No, I'm good.
I just have a quick question.
Ben, can you post that link in the Insider, please? Was it Ben, Brian?
Brian.
Brian, sorry, I said Ben, and then
Brian.
it scrolled up right instead of
Sorry,
sorry.
my apologies. Which one?
It's Brian, I'm sorry.
Yeah.
Put a link for what documents we can use to establish citizenship. So if we could post that link in the Insider, please.
Yeah, we'll grab it. And Brian, if you can throw that in, that would be amazing. Thank you. Or I'll try and grab it after the meeting and put it on the Insider as well.
Cecil had a question, if you scroll down, sorry. Keep going down. Oh, right there, follow up to my question regarding non-resident being a part owner. Your explanations seem to cover corporations, but or more specifically, this is a family member who wants to help out their kid who is a Canadian resident, buy a house to live in. Could there be an exception here?
I don't know of an exception to that,
No.
if they're gonna be a titled owner.
Okay, sounds like the answer is no.
It would be yes, though, if they just gave the money to the.
Condominiums.
If they give them money, yes. I mean, if, you know,
The
if
kid's the
that,
only one on title.
yeah, but if they're needing them to, you know, qualify for a mortgage or something like that, who knows what the situation would be, but
And Susan asks, condominiums are exempt?
no,
No.
This is more than 40, this is more than 40.
that's
More than
what else? Okay, did anybody else have any other questions for Binu while we've got him? I guess it's until we sort of see something go through the full cycle, it's gonna be difficult to anticipate how this is gonna play out or what level of enforcement the government takes. Because as long as this is caught prior to, by somebody, prior to the actual closing of the property, there's no reporting requirements that I'm aware of.
No.
There's no pursuit of, so if somebody moves along to somebody else, because that didn't work out, it only got so far in the transaction, there's limited enforcement or repercussions for giving it a shot, I guess, right?
yeah, from starting the beginning phases of things and not, you know, signing an agreement. There's not much that people would be aware of or any repercussions of that at that point.
There's no breach of law until it closes, that's
Yeah,
what we said.
yeah.
That's when the shit hits the fan and everybody's scrambling, agent listing, agent lawyer, everybody.
Just refer it.
You know.
Okay, I think, did anybody else who's joining us via Zoom, any other questions you wanted to jump in with for Binu? No? Okay. So I think Laura and I'll review the paperwork and we will make sure that we get things out to you guys. I think the direction is going to be that it would be advisable for you to execute the certificate of consent from the purchaser when you start working with a buyer, and that is the 309 version. Or sorry, that's real. So that would be at the point of initially starting to work with a buyer, not at the point of executing on the transaction. That's where it's going to be most valuable for you because you put in a lot of hard work. You may as well know up front whether or not you got something that you can bring to fruition.
But that's only if you have an accident, right?
No. What?
Wait until the shit hits.
Just bring that forward.
You're almost within reach for a slap on that.
Bring that forward. More about every single time, it's just, it's a gray area.
Yeah.
You know what I mean, so that's why I think it's just.
Very dangerous, you go first.
No, but you know what I'm talking about, it's a little bit,
Yeah,
right?
it is, like, you better have it as a constant.
I just wanted to bring it
Apply
out.
this to
Okay.
every single client.
So this is, so.
Okay, one at a time though, because I know everybody via Zoom cannot hear everything that's being said here.
I do have, to just slightly better. Vacation properties and our US cousins.
Yeah.
And again, we may be due diligent if we're selling a vacation property. However, a buyer's agent who may have thousands of Canadian relatives comes up from New York State, sounds Canadian, looks Canadian in that way. You can't, there's no accent. The buyer's agent doesn't do the due diligence because, oh, well, you know, Aunt Sarah's got this property right over here, Fred's got this property over here, I want to buy the one in the middle. And then they don't do their due diligence. That's where you can get into a.
Yeah, so can I make a recommendation here?
Yeah.
I would strongly recommend that the certificate and consent of purchaser on the buy side of the equation. There is no looks like a Canadian, talks like a Canadian, sounds like a Canadian.
Yeah.
There is nothing here that is absolutely.
It's on.
It should be standardized.
This should be applied to all of your buyer clients.
Guaranteed somebody's gonna screw up.
Indiscriminately, because there is no assumptions to be made here, and if you're making them, boy, are you putting yourself in a hot seat. So I would highly recommend that be used with all of your clients. And the Schedule C, we will put out so that it can be attached to your listings. And any listings that are out there, we can certainly get the administrative staff to add those on your behalf if you would like that as well. So
I have one question. There's Canadian citizens living abroad for many years. What status do they use?
In this situation, they're not gonna be covered by that ban.
No?
No.
They wouldn't be a permanent resident anymore. Right?
No, they're still Canadian citizens.
So that's fine, right?
Yeah, they're still Canadian citizens. They, for other purposes,
Yeah.
they might be considered a non-resident. Yeah, but for this purpose, they're
They
Canadian
can buy it
citizen,
when
you're
they sell
fine.
anything.
That's-
Okay.
No, I just know you start doing it for everyone because there's people who have my daughter-in-law speaks English without an accent. Oh, sorry. Start using this with everybody. My daughter-in-law is German, she speaks English without an accent, you would never know. She was not a citizen, so, or resident. So
Gina, I think
everything.
what we could do is create a clause similar to that one on the Schedule C you're talking about, just so that we have one less people to carry with us, and maybe include that in the Schedule B, that protects us as listing agents. And maybe also what we could do is, because under the buyer rep, there is a field there to add other. You could, yes, and we just copy and paste that same clause onto the buyer rep, and I think that's covered us, our butts as buyer agents. And we've also covered ourselves as listing agent, yeah.
Can I make a suggestion to that? Manir just said, could we add it to our schedule? I would rather on the list side, have it as, instead of adding it to our schedule, have it as an additional one. Reason being, now we'll hash this out on our side. Reason being, it draws attention to the listing or the buyer agent. It's like, what's this about? Why am I getting my client to sign this? And the conversation starts. If it's buried in to a schedule Schedule B that everybody sees over and over again, may not resonate the same as it being a separate piece of paper. At this stage of the game, I think that is probably a better way to go. Adding it as a copy and paste clause to your buyer rep, I think that's a great idea because it does constitute that conversation at that point in time. Or you can go through with the certificate of and consent of purchaser. But for now, I think I'd like to see it as a separate, but we'll talk that out and get back to it.
Does it apply if a married couple, one being a Canadian citizen, the other one not, and doesn't fall into those three categories?
Yeah, that's what the Pierre's question that I didn't have the answer for, but I can give you.
I think I read somewhere that is an exemption, but I think it's only spouse or common law, but let's let him.
Okay, we'll follow up with that one. Give you some homework.
There you go.
All right, any other questions? Any other questions?
So now we're all xenophobic.
So just to let you know, if the business hasn't already got you deciding to retire, if you are deciding to retire, we have a licensed parking company called Legacy. You can refer your clients out, still get some commission on that, and your liability is washed away.
For just foreign buyers?
Just the ones with an accent.
Okay, I think that's a great place to wrap this up. I want to thank Binu and Liz very much for your time and all the information.
Oh, and Liz too.
We got a sneaking in question at the very end here. Should the non-resident part owner be a Canadian resident who has been living abroad for the last 10 years? Does that make a difference?
I'm not sure.
It's a non-resident Canadian citizen.
The
Yeah, I think
non-resident.
that,
As long as
that
they're
question
Canadian
should be,
citizens.
yeah, as long as you're Canadian citizen.
Canadian
you're allowed to
citizen.
buy your company.
Yes. If I'm getting this right, Cecil and Banu, maybe if they're a Canadian resident.
Then they're in, yeah.
Then,
Yeah.
so Canadian citizen, I think maybe the
I think
answer
that's what
question
he's wanting
is,
to ask. Are they,
yeah, if you're Canadian citizen, you're
Yeah.
okay.
you're okay?
The party in question is a Canadian citizen who was schooled here, lived here and worked, but has been living abroad actually for more than 10 years. Has a daughter here whom he would like to help buy a property to live in. How does that work? He's still a Canadian citizen.
And then, yeah, I think you're okay.
And the daughter's a Canadian citizen?
No. Didn't get an answer to
I
that.
don't think.
I'm sorry, I didn't hear that.
Is the daughter a Canadian citizen?
Yes, he is.
Okay, then you're okay.
But
You're
would
okay,
the
okay.
foreign tax stipulated
Yes.
on the father if he's on title?
So, if he's.
It's all-
The non-resident
that's a
tax.
Non-resident tax, yeah.
Okay.
That went up, didn't it?
It's a tax
Yeah, I think it's
question.
25.
Let's make national questions. All right, well, thank you, everybody, for joining us, and thank you again to Liz and Binu. Your information is always much appreciated. And we'll follow up with everybody on the brokerage direction for forms and consents and additions to the schedule or standalone Schedule C on this. Thanks, everybody, for your time. Really appreciate it. Hope you have a great rest of your week. Bye now.
Thanks.
Oh, anybody want information on legacy?
Yeah, I know.
That was still-